the guy out front. He's like, the highest experience in Wales. He's like, well, yeah, they're trying to treat him. Truly. I was like, that's a John Lee, bro. He's so high up. I was like, one of her classes, I'm curious, man. A lot of stuff. Yeah, I agree. Like, yeah, you have to know definitions. Yeah. And then it just adds piles up. And then, yeah, and then you read the rules, right? And then it's just not English. Oh, yeah. So I try to read them and then mark down like his definitions. But his definition is pretty simple. I think like 5 words from the.
Okay, so we have been working our way through lawyers' obligations to third parties and looking at all of the things outside of the attorney-client relationship that impact our responsibilities, particularly as officers of the court. We've done candor, we've done not filing frivolous motions, and we started looking at truthfulness and statements to others and the general catch-all misconduct. But we looked at a number of cases. Look on page 489, Flight from Sudan. And there, the exercise was simply to go through and look at what corroboration would mean, and should we believe our own client? And we ultimately determined that we should believe our own client. We saw a number of questions on page 491. Should we tell Baragabi about our conversation in order to file that affidavit? And we said, yes, of course, communication is very important with the client, and that's the only way we can ascertain the scope of representation. Should we file the affidavit? We said, not yet. We have a duty as officers of the court, and we also talked about comment 8 to Rule 3.3, which talks about that the lawyer must know that the testimony is false. And so willful ignorance isn't allowed under there. We said we would need to do a little bit more to make sure that we would be presenting a truthful representation of the facts. Then we said that we violate the rule by contacting other people in order to find out about our client, like El Parra and other witnesses that could corroborate his status as a political editor for this paper. We said, no, you implicitly give permission for us to go out and substantiate these claims as a part of our representation, so no violation of 1.6 there. And then the final question, no real answer to this, did we do our job too well? Did we learn too much? I don't think that's the case here at all. We have to learn in order to corroborate. And that's the way the problem was set up, that corroboration is so important that we have to talk to a lot of people. So that was on 489 to 491. That was the first part of the Flight from Sudan. Then from there we went to Flight from Sudan, problem 11.3, scene 2. So that brings us up. We resolved the doubts in favor of our client, which we should do if there's a basis to do so. And then we started moving through the analysis. And ultimately, we had a witness who could corroborate our story, but that witness had a problem. Provisional recommendation for asylum had been withdrawn by the government. That does not come up in the government's questioning. You see that on page 496. And then the question is, should we reveal that to the court? And in the real case, the students did not. The government tries to come back around and get it dismissed. The government, the court says, no, I didn't rely entirely upon that in making my decision. And really, we said, and this is on top of page 497, this testimony that was offered is true in every respect. The government did not ask the question that it was supposed to, so it's not a misrepresentation on our part at all. Did the immigration officials make a decision based upon the records you submitted? Has your immigration status changed? Those were the questions that the government should have asked, and we did not proffer any misleading testimony, so there's no duty to remedy anything because it was not false testimony. From there, we looked at the drug test on 11.4. Now, that was interesting because we had a number of scenarios going from outright perjury to slight misrepresentation to omission to telling the truth. And there you have a test that had been altered, and the question is, can we present that to court? That altered document could not be entered into evidence, we said, and probably the best way out of that situation would have been to get new test run and then present the new test. But here we submitted an altered document, and we had to answer these 4 responses on page 501. Is this the entire report? And if we say yes, Your Honor, that's a lie because it's not the entire report because we cut the part off of it that showed marijuana use. That's what I have, Judge. That's what I asked them to screen for. That's right, but that is what the lawyer said, and that is really a misrepresentation, a willful misrepresentation. C is, no, Your Honor, my client tested positive for marijuana, but I asked the lab technician to exclude that result. That's the truth, but then you're exposing your client to other questions. And then actually, Your Honor, I've just decided to withdraw this exhibit. That could lead down to the wrong road as well. And so this attorney answered letter B was the response. And the ultimate conclusion was a public censor. The lawyer intentionally evaded the plain and understanding questions of the judge. So we can't say, well, I didn't understand. He asked me what I tested for. That's what I told them to test for. Yes, but you submitted this altered document. So the punishment there was a public censor. Violation of a number of rules, including a 3.3, of course, and the catch-all misconduct. And so that's what brings us up to where we are now. But I want to sort of get, as we start off the rest of this chapter, the first thing we have to look at is 3.4. And so you have sort of an excerpt of it on page 506. Well, what is 3.4 and how it works? And then this is sort of a review too. I mentioned these cases sort of in passing in our last class. We're going to sort of talk about each of these cases and about the lawyer's duty to disclose materials that you may have received from the client. But what does 3.4 tell us? What obligations do we have here? 3.4 says, so notice this is another sort of obligation that we have outside of the attorney-client relationship. This is fairness to opposing party and counsel. So what are your duties here? And so also, how do you balance this with practice? So do you give opposing counsel everything, like if you're a criminal defense attorney, say, yeah, he really did it, so let me just give you everything, and we could sort of just move this along. I'll continue representing, but my duty under 3.4 is not to obstruct your access to evidence, so I give you free access to everything. Yes, go ahead.
I was just going to say, you can't unlawfully obstruct, you can't falsify evidence,
Okay.
disobeying obligations. So
Okay.
you have to give everything, but you also can't lie or use fraud to use it.
Okay, so, and lawyers shall not, that's good. And this first thing is letter A, unlawfully obstruct. So that's going to be interesting. We're going to see some cases from across the country in these excerpts, starting on page 508, that sort of impose different duties upon the attorney. And then that's going to help us set up this the church problem that we have to do. So a lawyer shall not unlawfully obstruct another party's access to evidence. So these problems are going to help us figure out what that means. And it goes on. Or unlawfully alter, destroy, or conceal. In a document and any other material, goes on and on. So we cannot unlawfully obstruct. Letter B, cannot falsify evidence. And we'll just go to letter C. Knowingly disobey an obligation under the rules. So, and notice this is a sort of reiterating our duties as officer of the court. So there may come times in the representation where this outside obligation, we talked about this in the beginning of the class, actually conflicts with our duties to the client. And so we have to make sure that we balance that. So we have, starting on page 508, these different cases. That must a lawyer turn over physical evidence after inspection and testing? Because notice what turning over the evidence does, it exposes your client to liability. So how do you handle this? I mean, they're all sort of over the place in terms of what you have to do. So for example, the Allwell case, what are they saying there? So these obligations are pretty clear. Most jurisdictions have adopted some level of 3.4. So Allwell says this: a lawyer could have kept a knife for a reasonable period of time. This may be the murder weapon. Reasonable period of time for examination purposes, but then turn it over to the prosecution as an officer of the court. So we have one, turn over this evidence. Now, what about that? Is that a violation of the 5th and 6th Amendments to use confidential evidence against your own client? How do you balance that? That's sort of a discussion on page 509. That's an argument that there's a picture of him, Professor Sisk is making about this obligation conflicting with the 5th and 6th Amendment right of counsel. What do you do there? How do you resolve that? So this is going to sort of drive our discussion of the church scenario, because the lawyer is often faced with keeping his evidence. I don't know about that. Giving it to the prosecution, that incriminates your client. Altering it or destroying it, that might be a violation of that. So what do you do? Should you be in the position of safekeeping incriminating evidence for your client? What does that expose you to? And how do you get around it? You say, well, I don't know. I don't want to know. Don't tell me. Go ahead.
Yeah, safekeeping incriminating evidence, you run the risk of obstruction of justice. So
that little thing, right?
Well, with the knife, like it's reasonable that that knife is going to be searched for in an investigation, so you have a duty to turn it over on your own initiative. And I guess the balance with that is your possession of it keeps the law enforcement agency from finding it.
Mm-hmm.
And even though I think it is a 6th Amendment issue, they say, like, yes, the prosecution is going to be more against your client, but they have a duty as well when they present the knife in court. They can't tell the jury where they obtained the evidence to find the knife or how they found it.
Mm-hmm. So what would you do? I guess, you're the lawyer. What would you do?
Well, you do testing.
Yeah. Okay, that's good. And notice in this case, is the knife, you see this little sentence, it turned out that the knife in Allwell's possession did belong to Gray, that's the client, but it was not the murder weapon. But Gray was convicted anyway on other evidence. So this argument of violation of 5th and 6th Amendment is sort of interesting and certainly valid and significant, but you notice that what's driving this is our duties as officers of the court. So Allwell says, yes, you can examine it for a while, but you have to turn it over. What about N. Ray Ryder? Must the lawyer refrain from concealing physical evidence? The answer to that is yes. So notice these cases are a little bit different. Allwell is sort of, you come into possession of what could be the murder weapon. Ryder is more active concealment. And notice here, so how do you balance this? Notice here, the lawyer thinks that he or she is doing the right thing. We don't want the client to destroy this evidence, so I'll just keep it. And we know these cases are reinforcing that the lawyer may not conceal or destroy evidence. So what happens to this lawyer? So can you make this argument? I concealed this evidence. This really isn't obstruction of justice. I had to conceal this evidence because I was afraid that my client might destroy the evidence. So actually, I'm doing a good thing. This attorney concealed the evidence, hoping to prevent the destruction of that evidence. So Ryder here gets his client to authorize access to a safe deposit box. He gets in, transfers the bank robbery money and gun from his client Cook's safe deposit box into his own, and says, I want to prevent my client from possibly destroying this evidence. What happens to that lawyer? You know, the investigators are going to get a search warrant, so the police officers get a search warrant. They search the lawyer's safe deposit box. And you know, that doesn't happen every day. You have sort of the breaking of the attorney-client privilege. You're going into an attorney's safe deposit box, and they found the evidence in the lawyer's box. So what happens to that lawyer? Yeah.
It's barred from practicing in front of the federal court because in their holding said that it was his purpose was irrelevant to him removing money to his own safe deposit box was irrelevant, that he knew or should have known that it was against the law for him to do this. It was obstruction of justice to withhold the information.
Okay, okay. So notice this is a 510. So this is unethical conduct. He is barred from practicing in front of federal court because of unethical conduct. And notice that, and it seems like this is a really good motivation. I was trying to avoid destruction of evidence, but the court says that that is irrelevant. You have the duty not to conceal evidence. That's irrelevant. You're basically an accessory after the fact. So he knew the law against concealing a stolen property and the law forbidding receipt and possession of this type of evidence. There are no exemptions for the lawyer who takes possession, so his good intentions were irrelevant. So that's another instance of do not conceal. Turn it over. People versus Meredith. So these are factually distinct. So the first case that we did was interesting. We have the lawyer having possession of what the defendant did. That's all well. And right, we have the lawyer concealing what the client did. Here we have an agent of the lawyer going out, an investigator going out and doing something. What happens in this case? People versus Meredith. So notice this is interesting. We have the lawyer sending an investigator out to retrieve the murder victim's wallet from behind his client's house. So the investigator does that. The attorney withdraws as counsel. And then what happens? What about this abrogation of the attorney-client privilege? Explain that. How does that work? So this is getting at when you go out to a site and you remove the object, what does that do to the attorney-client privilege? So go ahead, yeah.
So if you don't remove the object,
Yeah.
it's protected.
Uh-huh.
As soon as you do, some of those attorney-client privilege rights are waived.
That's right. That's right. And so what happened here? What's the result?
So the investigator that's testifying was employed by the guy's attorney.
Yeah.
And I guess the way they continue to protect what's left of the privilege is not asking the investigator who he was employed by.
Okay.
So I think that's how the testimony gets it.
Good. So good. So this conviction of the client is upheld. The testimony of the investigator is proper. The privilege is abrogated in terms of removing this wallet, but some of it stays intact. Of course, confidences and discussions and work product. And so we preserve what's left, as you point out, by not asking who employed the investigator. And that's the way to preserve that identity. Matt, go ahead.
So, what I'm taking away from this is that if your client tells you about some physical evidence, as long as you don't take possession of it or remove it, then there's no obligation like to the tribunal.
Yeah.
Okay.
And why is that?
Because of 1.6.
Yeah. I'll try that in 1.6. That's good.
You have confidences?
Yeah. And so that's really, and I think that's good. And so that underscores how broad 1.6 is. That's something that we learn. We could learn it from third parties, whatever. That's a conversation that we have with our client. We know where it is. We don't touch it. That remains intact. And so there's no obligation to turn on our client and reveal. We're not engaged in unlawfully obstructing anything. We're not falsifying anything. And we're not disobeying an obligation of the tribunal. We are representing our client by preserving that confidence. And I think each of these cases, we're going to do the last one too, each of these cases sort of illustrate that once you get involved more and more, you risk the bad consequences of being exposed, of course, to the rules of professional responsibility. Criminal conduct, you see someone was accessory after the fact, and totally obliterating the confidences that we have built into the rules, so that's important. Morale. So we know that a lawyer may not conceal or destroy evidence. Does the duty not to conceal physical evidence apply to documents? So we did the Orwell case, remember, previously, and that says that an attorney had a duty to turn over whatever he had to the prosecutor, even without having been asked for it. This attorney, Morale, consulted the ethics committee, returned the plan to the friend, and resigned from the case. The friend gave the kidnapping plan to the police. What about that? And this kidnap plan is not privileged, is it? So this attorney consults the ethics committee about what to do with a kidnapping plan that a friend of the client found in the client's car. The committee gives him advice. Now notice, when you get advice from the committee, that's good guidance, but I don't think that totally insulates you from liability. It looks good that you consulted with the committee in good faith, but it's more guidance. It's not sort of a binding opinion that insulates you from any liability. But it's good to get that so that you can say you tried to comply with the rule. So he gives it to Klein, the attorney. He consults with the ethics committee about what to do with it. And on the committee's advice, he returns the plan to the friend, resigns from the case. And then the friend who found it in the car turns it over. And that evidence is used against the client, Morrell, who was convicted. Of course, then Morrell claims that his attorney's action violated his constitutional rights. How is that resolved? What does the court tell? So notice, this goes even further. The court sort of looks at what happened in Orwell and says that this attorney had a duty to turn over the plan even without being asked for it. And so if the client's friend had not been willing to turn it over, the client would have had to do it himself. And there was an Alaska statute prohibiting concealment of evidence. So all these cases taken together, what runs through them is a lawyer may not conceal or destroy evidence, and when you do so, there are consequences that can open you up to liability. And so now we have a real case to help us apply this. This actually happened. So this was a case that happened, I think in Connecticut. Yeah. Page 514. So before that, in that little box on page 513, you have a summary of what we did in those cases. So how cases involving lawyers' concealment of physical evidence may arise. You have someone resisting a subpoena. You have law enforcement getting a warrant. Someone saying, well, my attorney turned against me, therefore this evidence is coming to light, which should not have come to light. All that is in the box on page 513. Now we have this real case. Problem 11.5, child pornography, a federal offense. So we are the criminal defense attorney. We have a relationship with the church. We're very prestigious and prominent in the community. We are even the former president of the City Bar Association. For years and years and years, we have represented this church, one of the most respected churches in the town, and it is a church where a former president once worshiped. We belong to the church, and our entire family is active in the church. Howard Gardner is the church's choir director, renowned director, has given great publicity to the church, traveled to Europe, even cut a few albums, so this is major. But one day he gives his computer to another worker, Art Hefferline, to use, and Mr. Hefferline discovers child pornography on his computer. Mr. Hefferline informs the rector, and the rector calls us. We are the attorney for the church. So possession of child pornography is a federal crime. So our stomach is churning. None of this is known to the public yet. None of this is known to the public yet. And so we're together in office. We confront him, and he promptly admitted that he owned the computer and resigned. The rector hands the computer to us. Notice what the fact pattern says. There's been no publicity about this incident. The church really wants to keep it that way. No charges have been filed yet against Gardner. And we realize that if these pictures ever get out, or if this news ever gets out, it's going to be devastating to the church. The church may never recover from this type of publicity. What will we do? What will we do? And so we have a number of different options that we should consider. Now, what's driving this, and this could happen in real life, nobody knows yet. Nobody knows yet. So what we have to do is figure out what we do moving forward. So, we have a number of options. One, we can erase the tapes. We could smash the hard drive. We could keep the computer in our office. We'll say keep it in no one. No. Return the computer to Gardner. Just say it's your computer. Deliver it to the FBI. Give it back to Rector. Tell him, do something with it. I don't want to know. I'm just thinking all kinds of stuff. Tell Hefferline, you take it to a pawn shop and get a ticket. False. Yeah. I mean, an exchange ticket, when you take it in, you get the you take any number thing. So all these are kind of keeping the computer or doing something with it. Oh yeah, I forgot another one. So we're in trouble. What do we do? And I just put 2 or 3 more up there just to show you that it could just keep going on and on. So the book just goes up to deliver a computer to the FBI. So what do you do here? So before you answer, step back and think. This is a good review of everything. You know, confidences, all of that scope of representation, who you represent, and that is going to drive your response. So you have to sort of think about that. Mr. Johnson, cancel your head.
All right, sir. So yeah, this is a complicated problem. So we don't represent the guy who owns the computer, right?
Right, who do
So
we represent?
The church. So
Okay.
we want to do what's in the best interest of the church, and they feel like that this not going public is in their best interest. So 1 and 2 go directly against 3.4, and so does 8, I think.
Okay, so we represent.
And so
So why do you say these two?
because we're destroying the evidence and throwing it in the junkyard is kind of concealing it. I think keeping it.
What if we say it's our computer?
Well, if it's our computer, then we're committing a felony, so I don't want to say that one.
Okay.
Because and that to me is like why I wouldn't get involved with the computer. But then also I feel like if you return it, you know that it's there, so you're kind of helping them and assisting in the furtherance of this crime.
So return it to who? What are you talking?
Return it to anyone besides the FBI is how I feel. So I feel
Okay.
like 4.1 makes us kind of have to, but I'm kind of jumping. I'm scattered. So.
No, because okay, so that's fine. So break it down. Tell us what you're saying about 4.1.
So 4.1, I think way back in the book it said that if we're assisting in the furtherance of crime or fraud, we have to disclose or
Okay.
reveal, and that's an exception to 1.6, and that works with the 1.6b 2 and 3s.
Okay.
So that's why I think that we have to conceal, especially because 3.4 doesn't let us do a lot of these other options.
Okay.
The pawn shop one is crazy. That just sounds like crime and fraud. And at a pawn shop, I think you got to give your ID. So it just sounds.
Well, that's why I said false.
False name. Okay, yeah. So that one's. I'd throw that one out. I mean, when you get involved, I think it's pretty bad. Like you were saying earlier. Give back to Rector. Tell him to do something with it. I don't want to know. I mean, but it could still come back to you. So I think 5 and 6 maybe the best option. I think 3 we get rid of because I don't like keeping that computer.
Okay. That's good. You got us good. So let's think about these things. So we got a lot of bad options, and we eliminated most of them by looking at the rule. We don't want to unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document. Oh, I forgot to say something. There is something working here. Maybe one way out of this is to say this. We don't know that there's no investigation pending. So if there's no investigation pending, how do we have a duty to turn over? We don't know about any subpoena or anything like that because no one knows yet. We have the advantage of time, and so we can think about it. This has not broken. There's only like 3 people who know about it. Director, us, well maybe 4. The director, us, Gardner, who is computer, and then Hefferline. If there are 4 people who know about it in the whole world, maybe we can just write it out in this manner.
That was my question, is because the rule reads another party's access, and there's another party at this point, it's not being investigated. And also, the rule says unlawfully obstruct. If there is another party, then I'm sure there's a law about, not falsifying or hiding evidence, but if it's not an investigation, there would have to be, in order to violate that rule, there would have to be some law saying, basically, you have to snitch whenever you know someone's doing something, which I don't know if there's a law like that. But also, there's a risk of becoming involved in a conspiracy. If you have to, like, affirmatively tell this person, I'm not involved in your porn thing, and get everyone to know about it. I'm not involved. That's the only way you could, have a valid defense against conspiracy to conceal child porn or whatever.
Well, yeah, but that's good. So this is dangerous though too because this is a federal offense. We know that it's a federal offense though. What about that? See, that's what it says in the problem. That's what that one little throwaway sentence makes it difficult. Possession of images of child pornography is a federal offense. So we know that.
But is it a federal offense to not tell on someone because they're committing a federal offense? Because the rule says you have to unlawfully obstruct, so there has to be something illegal, not just.
Well, we're already illegal because we have it.
We're in
And I
possession.
guess the question is, what do we do with it? And you're right. There is no other party now. There is no investigation. But possession itself, this is it's viewed as this crime is so heinous that if you just have it, possession of child pornography is a federal offense. So the other question, I guess, is not telling or concealing is that a crime because we know that it is a federal offense. And I think there's a colorful argument that, well, nothing really is happening now. We just have to figure out what is our best option. So what about keeping the computer in our office or delivering it to FBI or giving it back to Rector and saying, do something with it. I don't want to know. Yeah, go ahead.
I think given that the argument that you mentioned about how since there's not an open investigation, I see where that argument's going, but I think I would counsel my client about the likelihood that something would come out and the damage it could do to the church if you weren't proactive. And by delivering the computer to the FBI, that is showing that the church took proactive action and took steps to get rid of the person that had done that in the first place. And I would talk about how that counsel them that removes a lot of liability from them. And that given their their position in the community, that would be their best option, even though they're worried about because clearly they're worried about their image, and that's the focus. But getting ahead of it, and then just everything that because churches are this kind of issue is in the media quite a bit. Churches and getting ahead of that would be beneficial for them.
Okay, so let's That's good. So how would you handle, since you represent the church, you've made this consideration that this is in the best interest of the church. It's going to hurt initially to get this out, but how would you handle sort of delivering this to the FBI and bringing the church leadership along so that they understand that? Because one of the things they're going to say to you is, you're hurting us. If we could just keep this quiet, no one knows yet, and if there's 4 people, maybe these 4 people can keep, Gardner certainly isn't going to tell, and we just need to work with Hefferline and the rector, and we're fine. So how do you sort of say, well, this has to come out, this is my duty as officer of the court, and say, officer of the court, you represent us, you represent the church, we don't want the church to be hurt. How would you sort of bring that along to deliver to the FBI?
I would definitely make sure that they understood that the possession itself is a federal crime, and that simply, by hiding that computer away, or even if they try to get rid of it and some evidence came back later, that would definitely, be harmful later on.
So we're making it worse the longer we hold on to this thing.
Right.
Yeah. What about, is there a way to sort of slide around this and give it to the rector?
Well, I would think that would still be that's still a problem for the church. That's still possession.
Yeah.
And then,
Do something with it. Get it away from the church. Take it to your cousin's house in Akron and then put it in the basement, then come back.
I don't think that's a good option at all.
Because that's more like obstruction too. Can't conceal. So, and we don't want to keep it in our office because that exposes us to liability. So we don't want that. So that may be the best approach. And we just have to bring along the church. Now, what do you think happened? Now, this attorney is extraordinarily prominent, and this church is prominent. This is former President George Bush's, his father's church in Connecticut years ago, and this is a major attorney during that time. So, what do you think he did? He were in class sometime. Go ahead.
Didn't he destroy it for $100?
Yeah, how do you know about that?
I don't know, I just feel like I remember it.
Okay, yeah, he did. So he, now notice, that's why I was pushing, well, it's very quiet, nobody knows, and this isn't going to come out, but it did. So he took the laptop and destroyed it. And so we've seen all these cases, duty to turn over incriminating real evidence. The attorney should not be the depository for incriminating evidence, criminal evidence. We shouldn't keep it. And so the real case, the attorney's name was Philip Russell. He took the laptop and destroyed it. So this opened up a world. So this is right around the time Sarbanes-Oxley was coming in, and this was the first case where the defendant was charged under Sarbanes-Oxley for non-corporate crime, and without knowledge of an investigation. The big thing with Sarbanes-Oxley is you're being regulated. You should know that there is pending investigation, so you have a duty to turn over. Here, there was no concern about whether or not there was an investigation or not. So they sort of used a creative approach to Sarbanes-Oxley to indict this attorney. The government took the position that actual knowledge of an investigation was not a necessary element of the crime. So, of course, Russell, the attorney, ultimately challenges this. They go back and forth, and he is ultimately pled guilty to a crime called misprision of a felony. What is that? That's sort of old and creative. What's misprision of a felony? You ever heard of that before? Amen. So this is an answer to Mr. Manley's point. Can you be charged for not telling about something? Yes. Since this attorney did not tell or disclose, he's charged with misprision of a felony. So what do you think happened to him? What type of punishment? So he pleads guilty to misprision of a felony, 6 months home confinement, $25,000 fine, 240 hours of community service, and 6 months voluntary suspension of license. 6 months voluntary suspension of license. So notice the argument that we were looking at, this notion that that we don't know if an investigation is coming or not, and that triggers the duty to disclose. The court rejected that argument. And it looks like the quiet record got 5.5 to 6 years in prison. $50,000 fine, treatment and registration as a sexual predator. So notice this, page 517 says, the bottom line is that a lawyer should never assume that the documents that are or could be pertinent to a civil lawsuit may be concealed or destroyed, even if a suit has not yet been filed. So you still have, this is why our problem was driven by our concern with obstruction of justice. You still have that. So whether an investigation is on the horizon or not, that doesn't determine the boundaries or parameters of this notion of obstruction of justice. So we have at the bottom of page 517, 3.4D, fairness to opposing party and counsel. A lawyer shall not fail to make reasonable due diligent efforts to comply with a legally proper discovery request by an opposing counsel. So the guiding principle is efficiency, a free-flowing discovery. That doesn't mean that you do opposing counsel's job for them, but if it is a response that you can answer in terms of discovery, you do so. Now what about this case on page 518, this example? So you have a car crash, an employee of allied contract loses control due to speed, and then there's some discussion about how the accident occurred. It crosses a line and it kills Lester's wife. Attorney represents Lester in a suit against the concrete company. Allied's attorney saw on Lester's page a photo of Lester holding a beer can while wearing a t-shirt with the legend, "I love hot moms." The attorney then issues a discovery request for all pictures and messages on Lester's Facebook account. So notice that's interesting. So social media, that could be play upon credibility. Murray, the attorney, then asked his paralegal to advise Lester to clean up the Facebook page. We don't want any blow-ups of this stuff at trial. The paralegal so advised Lester in an email. Complying with Murray's advice, Lester then deleted 16 photographs. Later, when the court ordered the attorney to submit all logs of this email between the paralegal and Lester, Murray omitted the particular email from the log. That particular email talking about cleaning up the Facebook page. Now, why would the court sanction the attorney for such a huge amount? Why was the attorney sanctioned, I guess? And suspended 5 years. So deleting some images on the Facebook page leads the attorney to be sanctioned and suspended for 5 years. What's driving it? Why do you think that happened? And you know, you have this little footnote too that says, by contrast, some of our opinions advise that the rule is not violated before any litigation has been initiated, that a lawyer advises the client to delete things from the social media that could be relevant to foreseeable lawsuits. How do we explain this sanction? Or is there a way to explain? Could it be that this is sort of like the case where we were talking about the altering of the medical document and then presenting that to the court? Is that the same thing, or is this different? So we delete 16 photographs. The court orders the attorney to submit a log of emails between the paralegal and Lester. So this is the paralegal talking to the client, Lester. Murray omitted that particular email from the log. So I guess the court doesn't get the email that tells the client to clean up this Facebook page. What do you think drives this sanction? Yeah, go ahead. Okay, so you think that's the same as the case with the altered medical document that was presented? That's fairly close. Yeah, go ahead.
I think this makes it even worse because
Yeah.
they can't allow discovery. They already asked for the Facebook stuff, and then they deleted it, and then they also altered it in the log and everything else on top of it.
Okay, so that's even more. Okay, that's good. Paul, then it's talking.
Well, you can object to a discovery request. So, I mean, if they really were that worried about what's on there, they could at least object to it first and just see if that would work.
Mhm.
And then if not, I mean, you can't take that out regardless. But there was different steps they could have taken before deleting.
That's it. So that brings us. So when you say object, so you object, and they say we still want it. So you would not have deleted those photographs. You just would have objected, and then if the court says turn it over, what happens?
You can turn it over.
Okay, but you would just object and keep the photo.
Yeah, I mean, if you,
Yeah.
just to save this whole sanction and all
Yeah,
that,
yeah.
that's just an easier step, and then if you lose that argument of objecting to a discovery request, then, I mean, you might turn it over to this.
Yeah, and then it's not really the end of the world. You could sort of contextualize it. You could make it work for you, or you could just admit it up front and then take the sting out of anything that would be damaging to credibility. That's good. Sorry.
I would be right with what she said, she kind of stole my point, but it makes no sense to me that they didn't object to the discovery request first, because based on, you know, the context of the situation and what the guilty party was asking for, it didn't even seem relevant to the current litigation that's about to happen. And 3.4D has that sort of like, you know, reasonable factor in that, you know, worst case scenario, and this is assuming that another path is taken and that things weren't deleted, that they could use 3.4D defendants, I'll think that's what they're telling us to do is not within that realm, that we must comply.
And so you made a point about relevancy. I think the reason they want this is to paint the party in a certain way, so in terms of credibility. So that's your relevance point. But you're saying, in terms of good faith, what does 3.4 mean? I didn't say that again.
I can't remember quite the wording of 3.4D. It said,
No, but what you're saying about good faith and how to comply with it.
Basically, sorts of efforts that the opposing party is asking for all of this, like literally everything on this social media page, that is, I don't know, to me, that's extremely unreasonable. And even not taking into account, like, the fact that maybe you can delete something, like, because once something's on the internet, it's on the internet for good. It's on, like, on another site that might have it.
Right.
So that would require, to me, like, checking the entire web, not just, like, Facebook or anything, but, like, going through Google Images and seeing this picture of everywhere else. That seems like a really, that seems like unreasonable effort for you to have to go through comply with this request.
That's true. That's true. Good. So let's go back. I'm going to sort of move through this chapter because that was the last problem, but I want to sort of highlight a couple of things. Look at on page 518, it's duty to disclose adverse authority. So the thing to remember about this rule, and this is candor towards the tribunal again, and this is 3.3A2. Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. So you're litigating in the 6th Circuit or Western District of Kentucky, and you notice that opposing counsel has not cited something from the 2nd Circuit that goes directly against you, damaging for your case. The only thing is that it is in the 2nd Circuit. Do you have a duty to disclose that decision to the court? Still a Federal Circuit, directly on point, goes against you, but it's from the 2nd Circuit. Do you have to disclose that under 3.3A2? Oh, and the circuits are in flux. You know that this is going to go to the Supreme Court at some point. Yeah.
It's not the controlling jurisdiction.
Right. That's good. So, not controlling jurisdiction. It might be something you want to distinguish or something, but you don't have an obligation. Now, if there's a 6th Circuit case that was directly on point, goes against you, opposing counsel does not reveal it to the tribunal, you have a duty to do so. And that may seem like it hurts you, but that is because you are an officer of the court. Disclosures in ex parte proceedings you see on the top of page 520. But that requires that in this one-sided proceeding, a lawyer who knows something materially that will enable the tribunal to make an informed decision has to disclose those, regardless of whether or not it is adverse or not. So again, that is your duty as an officer of the court to disclose that. On page 525, we have public and trial publicity. Now, someone take 3.6 and tell me how does that work? So you have a number of cases. There was a case that went up to the Supreme Court. You have a picture of the Attorney Gentili. And in that case, the court said that these disciplinary rules were unconstitutionally vague. And there was a First Amendment component to it, too. Whether or not advertising is protected speech. And, of course, advertising is a lower-level speech. It's not like political speech. So we're less concerned when the state is regulating the content of those messages because they're not the high-level speech. They're commercial speech. And there's a hierarchy of speech under the First Amendment. But anyway, if you have to tell me what does 3.6 say, what does it say and how does it work? So what can you say in a very public trial to protect your client and not violate this rule? So all of this comes out of an attorney you see on page 524 and 525 commenting on a case in order to protect his client. And there was some language in the rule that talked about elaboration of the charges or the general nature of the charges. Those were too vague to convey clear information about what was prohibited. The court 5-4 concludes that that rule was unconstitutional. So in response, the ADA amends the model rules. Lawyer who has participated or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. That's long. What does that mean? So what can you say in representing your clients? You say, we're going to win this case. The prosecutor's office set my client up. We know that they plant evidence every day, and the judge better rule the right way on my motion to suppress, where that shows that this is a full-blown conspiracy against my client. Can I say that? Can I say that? What's wrong with what I just said? I'm protecting my client. Yeah, I have to push back though. That's why it's hyperbolic. The prosecution is really aggressive. Yeah.
I think the rule is just kind of encouraging attorneys to say, like, if you're having a like maybe just say, I'm not able to defend it.
Okay.
That, like, in those situations where the defendant saying something false.
Right.
Sometimes a lot of times it's probably just not your client, not just saying.
So good. So you're bringing everything in. So on some level, I have to have a good faith basis to say this stuff. I'm saying this against the prosecutor's office. I'm impugning the integrity of the court. And so all the things that I said could materially impact this adjudication. Saying something like the judge better rule the correct way on these motions to suppress. So it's difficult to really strike a balance. When you see comment 1 between the right to a fair trial and safeguarding the right to freedom of expression, because the First Amendment is here as well. So you have to make some choices there. But it really also shows that what happens under this rule is really contextual. So my hypo went too far. Impugns the integrity of opposing counsel, talks about the judicial process as flawed, and does all of those things. So that's 3.6. What about this last on page 530, 531? This is interesting. So this is we've made a big deal. The reason that this is in the book, we've sort of emphasized our duty of candor to the tribunal, fairness, not falsifying evidence, not obstructing evidence. But Professor Subin argues that the criminal defense lawyer has a different objective, a different goal, protecting the client. And so that may mean casting doubt on a truthful victim. And when you make that choice, what does that mean? So lawyers may be in this position. The defendant would not have to prove whether the complainant made the false charge to account for her whereabouts that evening or to explain what happened to her missing watch. And he's talking about different components of this story to use to discredit the testimony of a truthfully testifying witness in challenging a sexual assault charge, rape and robbery. Then on page 532, the lawyer is a witness. The lawyer cannot be a witness for obvious reasons. So because you won't be able to clearly differentiate what role the lawyer has. Is the lawyer still an advocate or a witness? The same thing for judges being witnesses as well. And then finally 3.E, fairness to opposing party and counsel. And this is sort of illustration of Ms. Harper's point when I said, when she said, do I even believe that it's true? Do I have a good faith basis for even saying this? Lawyer shall not at trial allude to any matter that the lawyer does not reasonably believe is relevant. So good faith basis, relevancy, all that goes hand in hand. When we come back, I'll just summarize and pick up here, and then we'll start into chapter 12, lawyers' duties to adversaries and third party. Have a good afternoon.